Hi everyone, I hope you all are doing good, and today we'll be starting with Limitation Act. या तो आज हम लोग लिमिटेशन एक्ट स्टार्ट करने वाले हैं एंड यस तो लिमिटेशन एक्ट आपने थोड़ा सा अगर पहले पढ़ा होगा तो बहुत ज़्यादा डिफिकल्ट नहीं है, बहुत ज़्यादा डिफिकल्ट नहीं है, बट द ओनली थिंग इज कि आपको ये ध्यान रखना है कि जहाँ जहाँ इम्पोर्टेंट क्लॉजेज आएंगे वो खैर मैं बता दूंगी, उन चीज़ों का आपको ध्यान रखना है। बाकी बहुत इंपॉर्टेंट फॉर योर एग्जाम्स, नॉट लाइक कि उसमें बहुत ज़्यादा पढ़ना है, आपको बहुत डीप में जाके पढ़ना है। सिर्फ और सिर्फ बेयर एक्ट प्रोविजन पढ़ना है, उसमें भी वो बेयर एक्ट प्रोविजन जो कि इम्पोर्टेंट है। ठीक है, और एक्ट भी छोटा सा है, तो ऐसा भी नहीं है कि बहुत ज्यादा टाइम लगेगा। क्लोज टू 3 और 4 मैक्सिमम क्लासेस लिमिटेशन एक्ट कंप्लीट हो जाएगा। ओके, क्या सो ओके, सो लिमिटेशन एक्ट, तो हम पहले यहाँ पे शॉर्ट टाइटल एक्सटेंड कमिटमेंट से ही स्टार्ट करेंगे इसको। Now this act may be called, yeah, so this act may be called the Limitation Act 1963। ठीक है, तो आपको ईयर थोड़ा सा ध्यान रखना है कि कौन से ईयर का है लिमिटेशन एक्ट। 1963 का है। ठीक है, द लिमिटेशन एक्ट 1963। नाउ इट एक्सटेंड्स टू होल ऑफ इंडिया। ओके, आपको पता है कि जम्मू एंड कश्मीर वाला जो प्रोविजन है, प्रोविजन था, एक्सेप्ट जम्मू एंड कश्मीर जो पहले लगा रहता था ना, यहाँ पे सारे एक्ट्स में था। दिस एक्ट अप्लाइज टू ऑल द to whole of the territory of India except the territory of जम्मू एंड कश्मीर। तो ये वाला जो प्रोविजन है ये अब हट चुका है। दिस प्रोविजन हैज बीन रिमूव्ड एंड इट हैज बीन रिमूव्ड बाय फर्स्ट ऑफ ऑल इन विच ईयर you have to remember. Okay, this is an important question. So it was removed in 2019, 31st October। ठीक है, या तो 2019 में ये रिमूव हुआ था। अब ये जो एक्ट है, दिस एक्ट अप्लाइज टू होल ऑफ इंडिया एंड नॉट जस्ट लिमिटेशन एक्ट, in several other laws also this amendment has been made. Now it shall come into force on such date as the central government may by notification in the official gazette appoint। So it shall come into force on such as the central government, so whichever date जो भी central government बताएगा उस दिन से जो हमारे लिमिटेशन एक्ट है इसका इन्फोर्समेंट हो जाएगा। अच्छा, वन बेसिक क्वेश्चन, आपने इतना लॉ पढ़ा है, यू आर गिविंग दिस एग्जामिनेशन, ग्रेजुएट हो आप, पोस्ट ग्रेजुएट हो, तो यू नो व्हाट इज द डिफरेंस बिटवीन कमेंसमेंट डेट, इन्फोर्समेंट डेट? ओके, या इन दोनों में आप मुझे डिफरेंस, अगर आपको पता है आप मुझे कमेंट करके बताएंगे, नहीं पता है तो यू शुड नो दिस, पता करिए इसे। ठीक है, हम अपने सब्जेक्ट पे वापस आते हैं। सो इट शैल कम इनटू फोर्स ऑन सच डेट एज द सेंट्रल गवर्नमेंट मे बाय नोटिफिकेशन अपॉइंट। तो जिस दिन को भी सेंट्रल गवर्नमेंट अपॉइंट करेगा उस दिन से इसका इन्फोर्समेंट हो जाएगा। ठीक है, इस दिन से वो ये जो एक्ट है ये इन्फोर्समेंट में आ जाएगा। now we come to definition part। so in this act, unless the context otherwise requires, applicant includes, applicant कौन होता है? जो कि एप्लीकेशन फाइल करता है। ठीक है, the one who files the application is called the applicant। So who are all are included in the applicant under the limitation act? First of all, a petitioner is there। Okay, petitioner कौन होता है? You know, the person who files the petition, you know what a petition is, I'm assuming this। तो petitioner होता है any person from or through whom an applicant derives his right to apply। any person जिससे या जिसके थ्रू कोई एक जो एप्लीकेंट होता है वो अपना राइट टू अप्लाई डिराइव करता है, ठीक है। तो एनी पर्सन फ्रॉम होम द राइट टू अप्लाई इज डिराइव्ड, ओके, or through whom this right is derived. Thirdly, in petitioner comes any person whose state is represented by the applicant as executor, administrator, or other representative. So applicant will also include any person's executor, any person's administrator, and any person's representative. Okay. So applicant, in the definition of applicant, these all people are included. First, affirmative petitioner. Secondly, any person from or whom the applicant derives his right to apply, and thirdly, any person from this whose state, any person whose state is represented by the executive, administrator, or the representative. Now, clause B. What's given in clause B? Clause B says application includes a petition. In clause A, you studied that applicant includes the petitioner, application includes the petition. Okay, that's all for clause B. Now, clause C says that bill of exchange includes the hundi and a check. If you would have read Negotiable Instrument Act, NIA, there you will get a good definition of bills of exchange. You have to go and read section 4, section 5, and section 6. All of these three sections are very important under Negotiable Instrument Act. In fact, all of the Negotiable Instrument Act revolves around these three sections. Okay, so you have to be very sure when you read Negotiable Instrument Act to cover section 4, to cover section 5, and to cover section 6. This is basically promissory note. Then section 5 is basically your bills of exchange, and then section 6 is your checks. Okay, bill of exchange basically includes the hundi and the check. What is a hundi? So hundis are not recognized under the Negotiable Instrument Act, because Negotiable Instrument Act provides for these three kinds of instrument: a promissory note, a bill of exchange, and a check, and some other instruments which are being mentioned later in the act. But it does not recognize hundi exactly or very expressly as a negotiable instrument act, as a negotiable instrument, but this definitely is counted as an instrument. Okay, so bill of exchange includes a hundi and a check. Then comes your point number D. Bond includes. So you have to be very careful when you're reading the provision, because sometimes it is written that bond means. Okay, so for example, bond means, and somewhere it will be written like includes. So you have to be very careful that where the term means is included and where the term includes is written, is mentioned. So you have to be very careful. So wherever it is written means, okay, that means it is giving the meaning of that particular term. And wherever it's written includes, so includes definitely doesn't mean the meaning. Includes does not mean giving the meaning of that terminology, but includes means to include. Okay, so bond includes any instrument where a person obliges himself. Okay, he is obliging himself to pay money to another. To pay what to another? To pay money to another, on condition that the obligation shall be void if a specified act is performed or is not performed, as the case may be. Okay, so what is a bond? A bond is basically an instrument where a person puts himself into an obligation to pay money to another. Okay, so basically an obligation on a part of one person to pay a certain amount of money to another person. On what? On the condition that the obligation shall be void. Okay, and this obligation would be void if a specified act is performed. So if he does that act, that obligation would be void. And if he does not do it, then what? Then he is under this obligation. Okay. So basically, bond is made in order to fulfill an obligation. Okay. There's a condition that such obligation would be void if he performs such act, and if he does not perform such act, then what? Then as the case may be. Okay. Now, defendant includes who? Any person from or through whom a defendant derives his liability to be sued. So basically, any person from whom or any person through whom a defendant derives his liability to be sued. Okay? Then any person whose state is representative by the defendant as executor comes into this, administrator and other representative. So defendant may, there are 2 points included. Firstly, that any person from whom or through whom a defendant derives his liability. Okay? From whom from whoever person he is deriving his liability to be sued, and any person whose state is representative by the defendant. Okay, so basically it can include executor, administrator, or other representative. Then coming to the clause number F, clause number F says that easement includes a right not arising from a contract. Okay, so easement includes a right which does not arise. Achha, you might know this thing that what is easement? What is an easementary right? Easement is never, a part of a contract. See what it's saying? This is important. 2 clause F defines easement under the Limitation Act. So, includes a right which does not arise from a contract by which one person is entitled to remove and appropriate for his own profit any part of the soil belonging to another or anything growing in or attached to or subsisting upon the land of another. Basically, easement, an easementary right is the right where a person has the right to enjoy, the property or the land of another person. Okay? So includes a right not arising out of a contract. So you have to remember this thing. This does not arise of a contract. Means this is not a contractual obligation. This is not a contractual obligation to be fulfilled. You understand that? This is not a contractual obligation to be fulfilled, but this is something extra to the contractual obligation that has to be fulfilled. The person is not bound by the contract, but this has to be fulfilled. So one person is entitled to remove or appropriate for his own profit any part of the soil belonging to another. Okay? Or anything which is growing or attached to or subsisting upon the land of another. Matlab, any enjoyment on the land of another person, any profit from the land of another person would be termed under the easement. Also, the term includes is written. It does not say means. Okay, it includes. Then now see what foreign country. Obviously, foreign country means any country other than India. Nothing to explain in it. Good faith. Nothing shall be deemed to be done in good faith, which is not done with due care and attention. This is important. The meaning, the definition of good faith is also given under section IPC. Comment and tell me under which section of IPC. Okay. Now, good faith. Nothing shall be. Achha, what is the meaning of good faith? Anything which is not done with, or anything which is done with due care and attention is done under good faith. So, in order to term an act under good faith, it should be done with what? With due care. The act should be done with due care and attention. Okay, so that should be done with what? It should be done with due care and should be done with attention, due care and attention. Deemed to be done in the good faith. So both of these terms is important. What is attention and what is due care? Care means what a person of ordinary prudence would do under such similar circumstance. Okay, to be careful. Okay, and attention, okay, so due care and attention. Then plaintiff includes any person from or through whom a plaintiff derives his right to sue. In defendant, what we read, right to be sued. Here it will come right to sue. Then from or through would remain the same. Then any person whose state is representative by the plaintiff. So any person whose state is being representative by the plaintiff as what? As an executor, as an administrator, or as any other representative. It's easy, not a big thing. Okay. Now we come to period of limitation. This is important. What it says, period of limitation means the period of limitation prescribed for any suit, appeal, or application by the schedule and prescribed period means the period of limitation computed in accordance with the provisions of the section. Now, this is the most important definition in all of these definitions. Now, see what's written. Period of limitation is the period of limitation prescribed for any suit, appeal, or application. So, what are things are included into it? Suit is there, appeal is there, and application is there, right? Suit, appeal, and application. These three things are there. Now, period of limitation is the period of limitation which is being prescribed. Okay. So, for example, and also think by the schedule. Turn your bare act, and in the last, we'll see that there's a schedule given. And the schedule very clearly expressly gives the time period for every kind of suit, appeal, or application, or the time period within which such suit, appeal, or application must be filed. For example, there's an offense named A. For if the time period is given like 30 days, and offense name B like 6 months, like C 2 years. Generally, the most common period of time period which is given in the Limitation Act is 3 years. You will see this the most. You will see the schedule. Then for almost 75 to 80% of the offenses, the time period is given, which is given is 3 years. Okay, so that is called the period of limitation. Period of limitation is the time period which is given for the suitable application in the schedule. And then what is the prescribed period then? Prescribed period means the period of limitation computed in accordance with the provisions of this act. So prescribed period is the period which is being computed. You have to compute it. And how will you compute it? You go from section 12 to almost section 18, 19, somewhat around 20. Okay? So basically, period of limitation is the period which we compute. Okay? Here we will be studying these sections, and you'll see that there are certain terms and conditions which apply to the prescribed period. So, for example, the prescribed period is 3 years. But the period of limitation to compute it says that you have to subtract 1 day, the starting day on the day on which the period of limitation started. You have to exclude that period, and then you have to exclude the holidays as well. So इस तरीके से जो period which is measured, which is made, that is your period of limitation, and the period which is given directly into the schedule, that is called your the period which is given under the period of limitation under the schedule is the period of limitation, and the period which you compute as per the provisions of the Limitation Act is called the prescribed period. Okay, remember this. Prescribed period is the period which we compute as per the Limitation Act provisions. Period of limitation is the period which is given under the schedule of the Limitation Act. Okay, easy. Promissory note. अच्छा, promissory note is also defined है, इसके अलावा NIE में भी defined है. Okay. So promissory note means an instrument whereby the maker engages absolutely to pay a specified sum of money to another at a time therein limited and or on demand or at sight. Specified sum of money देने का promise एट अ टाइम जो भी लिमिटेड है, ठीक है, या फिर डिमांड पे, किसी टाइम पे, या फिर डिमांड पे, या फिर साइट पे, ठीक है। ये तीनों में क्या डिफरेंस होता है, ये तो स्टडी दिस इन एनआईए। टाइम लिमिटेड, ऑन डिमांड, एट साइट, these are terms related to negotiable instrument act. Okay, so promissory note not very important, just remember that, defined under 2k. Okay, then L is important. Suit does not include appeal or application, very important. Why? Because wherever in this act this word suit would be written, this will not mean application or appeal. Wherever they want to convey application or appeal, wherever they want to say or talk about application and appeal, they will talk about application and appeal. They will use this particular term application, this particular term appeal. Okay, so suit does not mean in the limitation act as an application or appeal. Application is different, appeal is different, suit is different. Okay, the suit does not include appeal or an application. Tort. See, tort means a civil wrong. We all know this, which is not exclusively the breach of contract or a breach of trust. ठीक है. So what ये जो tort की definition which is given, it's very common. You also know that tort is what a civil wrong, and it does not include breach of contract because breach of contract goes under the Indian Contract Act, and the breach of trust goes under the Trust Act. The acts with the provisions or the laws which are made particularly for trust. Okay, so tort does not include the breach of contract, and tort does not include anything related to breach of trust. Basically we did foreign country, good faith in H, I plaintiff. ठीक है, कैसे याद रखोगे? Weird example, but I am a plaintiff. I under the limitation. This is some weird tricks, but this is how you remember definition clauses sections, because you can't do anything else, right? So you will have to make your own tricks like this. Any person, yeah. Then J, period of limitation. K, promissory note. L, suit. M, tort. The last definition that's given here is of trustees. Trustee does not include a binamidar, a mortgagee remaining. Trustee does not include a binamidar, mortgagee remaining in possession after the mortgage has been satisfied, or a person in wrongful possession without title. तो ट्रस्टी में ये लोग नहीं आते. First is the binamidar. Second is the person mortgagee who is into the possession of the property even after the mortgage is ended. He'll become a trespasser, not a trustee. Similarly, a person in possession without title would be a trespasser, not a trustee. And a binamidar. Now let us start with what? Your major provisions. Now see, bar of limitation. Okay? This is a very, very important section. क्या लिखा हुआ है? Subject to the provision contained in the section 4 to 24. Means इसके बाद आने वाला जो section 4 to 24 है, subject to those provisions, every suit instituted, appeal preferred, application made after the prescribed period. Okay, we read about prescribed period. What is prescribed period? The period that we compute after the prescribed period shall be dismissed, although limitation is not set up as a defense. इसका मतलब क्या लिखा हुआ है कि see, every suit instituted. Okay, so a suit is instituted, an appeal has been preferred, and an application is made. So every such suit instituted, appeal preferred, and application made after the prescribed period. Okay? After the prescribed period shall be dismissed. Means you have to either adhere to what, to the rules which are to the provisions which are given under the Limitation Act. The purpose of Limitation Act is what? So that every person should be aware of his rights. Okay. There's a principle under administrative law or under the natural law that the person should come with clean hands and a person should be aware of his own rights. Because if a person is not himself aware of his own rights, how can he, accuse somebody else of infringing his rights, right? So a person should be aware of his own rights, and in order to be aware of his own rights, it is a very common principle that any person who is aware of his rights, or any person who is really concerned of his rights, or any person whose right is really infringed and is affected by that infringement or that violation, then he will come to the court without any delay. Okay, he will come to the court without any delay. He will not unnecessarily delay that thing. If his right is really infringed, if he's really affected by such infringement, he will come to the court without any delay. Correct or not? So this is why the Limitation Act was made, so that, for example, if for the offense of, for example, for the offense of theft, the period of limitation given is, say, 3 years. Acha, one more thing I would like to tell you. This Limitation Act applies on what? On civil laws. For IPC, that is of criminal laws, the period of limitation is given in CRPC. There are certain sections in the range of 472, 473, and near about 470, 468. So 468 to 472 के जो provisions है ना, basically, and then some ancillary provision. 68 to 72, 74 तक मान लो पूरा. So those are the provisions under CRPC which tells you or which give you the limitation period for what? For criminal laws. Okay, and you might have also heard that for criminal laws there is no such kind of limitation period. For certain laws there are limitation period, for certain laws there is no limitation period. Okay, so coming back to the point, so this limitation, this section basically puts a bar on limitation. So the purpose of Limitation Act is that any person whose right has been infringed, he should come to the court without any delay. And why should he come to the court on time and without delay? For example, if an offense has been committed today and the person approaches the court after 3 years, what will happen? The evidences will be vanished. Okay, the witnesses will go, you don't know. Okay, there will be no witnesses, or the chances of witnesses being present would be less. There would be no witnesses. Even if there would be witnesses, they'll forget. Okay, this is what happens in courts, that a witness will come, and if he'll be asked like what happened on this day 1 month ago, or say 15 days before, 15 days ago, he'll say I don't remember, or he'll say that as far as I remember. Okay, so if a person is forgetting the facts of any such act or scenario in 15 or 10 days, so what do you expect from a person to remember anything which happened 3 years ago? Okay, so there will be no witnesses, and even if there are certain witnesses present, then they'll not remember the exact facts or circumstances. There would be no evidences would be vanished. So all these things will happen. Okay, so Limitation Act basically prescribes a limit, which it sets a limit under which or within which the suit should be instituted, the appeal should be preferred, or the application should be made. Okay. Now, and so basically section 3 clearly says that if any suit is instituted, any appeal is preferred, or if any application is made after the prescribed period, it shall be dismissed by the court. And why the court will dismiss it? On the grounds that you were not aware of your rights. Where were you up till now? Okay. So because that person is not aware of his rights, the court will dismiss such suit, appeal, or application. And what does this line means? Although the limitation has not been set up as a defense, it says that even if the defendant, basically it is the right or the duty of whom? The defendant, to do what? To set up the argument of this period of limitation period. So in generally practically what happens, for example, a suit is filed by the plaintiff. Okay, now he files the suit. The defendant comes, and he can come and say to the court that the suit which has been filed by the plaintiff is barred by jurisdiction or barred by period of limitation. Barred by jurisdiction will not come jurisdiction. Barred by jurisdiction is what? That the court does not possess that jurisdiction to decide that case. Barred by limitation is what? That this uh, in this case, the whatever the facts of plaintiff are, it is barred by limitation act. Means the time period for instituting such suit, appeal, or application is over. Okay. So, oh, sorry. 1 second. So basically, it is the duty of whom? It is the duty um, of the defendant to put this argument of limitation act. But section 3 says that even if this defense is not set up by the defendant, still the court will dismiss such suit, appeal, or application which is made after the period of limitation. Right? Even if it is not set up as a defense, still court can interfere and put. Verna, if you see normally in other cases, court will only take into consideration the arguments or the evidences which are given by whom? By the defendant. Court cannot come up with its own evidence or argument against the plaintiff. Only those evidences would be considered which are given by the defendant. So here in the when we talk about limitation, even if the bar of limitation is not put up as a defense by the defendant, still the court will take into consideration. Okay. So subject to provisions, every suit instituted, appeal preferred, application made after the prescribed period shall be dismissed, though limitation has not been set up as a defense. Now, for the purpose of this act, a suit instituted, matlab ek suit, any suit instituted would include what? In ordinary case, when the plaint is presented to proper officer, in the case of a pauper, when the application for leave to sue as pauper is made, and in the case of a claim against a company which is being wound up by the court, when the claimant sends his claim to the official liquidator. तो सूट इंस्टीट्यूट कब माना जाता है? ऑर्डिनरी केस में जब प्लेन प्रेजेंट होती है. सूट कब इंस्टीट्यूट होता है? लिमिटेशन एक्ट के अंदर, जब प्लेन प्रेजेंट हुई है, या फिर जो पॉपर कौन होता है? इंडिजेंट पर्सन. सीपीसी अगर आप पढ़ रहे हो तो आपने पढ़ा ही होगा पॉपर इंडिजेंट पर्सन. ठीक है. सो विद द पर्पस विद इंडिजेंट इंसॉल्वेंट. ठीक है. सो पॉपर के केस में जब वो अपनी एप्लीकेशन देता है to take permission to sue as a pauper is made, and when the claim is made against the company, then when the claimant first sends his claim to the official liquidator, यहाँ माना जाता है कि suit is presented और suit is instituted. Any claim by way of a set off or a counter claim shall be treated as separate suit. तो यहाँ पे क्या पॉइंट भी क्या बोल रहा है कि कोई भी क्लेम बाय वे ऑफ सेट ऑफ और काउंटर क्लेम. अच्छा, इफ यू हैव स्टडीड सीपीसी अगेन, सी दिस इज लिमिटेशन एक्ट, दिस इज not really, but is considered to be a part of civil procedure code. So here we will be talking about CPC again and again, and I hope you have prepared CPC well. Okay. तो सेट ऑफ क्या होता है, काउंटर क्लेम क्या होता है, ये आपने पढ़ा होगा. पढ़ा है. और इसका okay, I'll ask this to you later. Just I'll make sure कि मैं आपको लास्ट में इसका एक क्वेश्चन पूछूं. Okay, first we'll complete our syllabus because we are already very late into it. ठीक है. तो सेट ऑफ अ काउंटर क्लेम में If you know, just do tell me the difference between set off and counter claim in the comment section, because we don't really have so much of time to discuss each and everything of CPC right here. So by claim, any claim by way of set off or counter claim shall be treated as a separate suit. So any counterclaim and any set off is definitely what, a separate suit. It is treated as a separate suit and shall be deemed to have instituted cup in the case of a set off when the on the same date as the suit in which the set off is pleaded. ठीक है, जब set off को plead किया जाएगा. And in case of a counter claim, on the date on which the counter claim is made in the court. ठीक है, set off कब माना जाएगा instituted हो गया है, on the date when the set off is pleaded, and in case of counterclaim, when the counterclaim is made in court. Then an application by notice of motion in high court is made when the application is presented to the proper officer to the court. Okay, I don't think there's too much to explain into this. इतना याद रखिए कि सेट ऑफ का ये बस वर्ड याद रखना है, अपन को डिस्क्रिप्टिव तो करना नहीं है. तो आपको कैसे याद रखना है कि सेट ऑफ जब आएगा, सेट ऑफ कब होगा, जब प्लीड होगा. काउंटर क्लेम कब होगा, जब मेड होगा. ठीक है, एप्लीकेशन टू हाई कोर्ट कब मानी जाएगी, दे दी गई है जब वो प्रॉपर ऑफिसर को दी गई है. ठीक है, इस तरीके से. और सूट कब इंस्टीट्यूट होता है, ऑर्डिनरी में जब प्लेंट इंस्टीट्यूट की गई हो, पॉपर में जब पॉपर अपनी लीव टू स्यू एज पॉपर दे, एंड जब क्लेम पहली बार ऑफिशियल लिक्विडेटर को दिया जाए, ये काम है कंपनी के केस में. ठीक है, so this is your section number 3. Now coming to section number 4 and 5. Let's see. Expiry of period, prescribed period when the court is closed. So when the prescribed period for any suit, appeal, or application expires on a day when the court is closed, the suit, appeal, or application may be instituted, preferred, or made on the date when the court reopens. Very easy. तो जो प्रिस्क्राइब पीरियड किसी भी सूट, अपील का या फिर एप्लीकेशन का जब एक्सपायर हो रहा है ना, तो वो एक ऐसा डेट है, मान लो 2 अगस्त को हो रहा है और ये है इस दिन कोर्ट इज क्लोज्ड, संडे. तो फिर कब माना जाएगा कि ऐसा सूट, अपील एंड एप्लीकेशन, the period of limitation or the prescribed period is ending on the next day or when the court reopens, on the date when the court reopens. ठीक है, अब मान लो सेकंड को, थर्ड को नहीं हो रहा था, फिफ्थ को हो रहा था, तो whenever the court reopens, then on that date. Done. Suit, appeal, or application, court is closed, instituted, preferred, made when the court reopens. Now, explanation. A court shall be deemed to be closed on any day within the meaning of the section if during any part of its normal working hours it remains closed on that day. So मतलब if on normal working hours में वो उस दिन closed है, that will be considered to be closed. ठीक है, मान लीजिए this was Monday, this is a normal working hour. ठीक है, and if on that date it's closed, then उस दिन माना जाएगा कि कोर्ट जो है closed था उस दिन पे. Now, section 5. Extension of period of limitation in certain cases. This is also important. Any appeal or any application other than application made under the provisions of Code of Civil Procedure. ठीक है, अब बहुत अच्छे से पढ़ना. Any appeal, any application other than an application under the provisions of Order 21 of CPC. What is Order 21 of CPC? You should know this. आप अभी भी पढ़ रहे हो, सिलेबस में पहले भी पढ़ा होगा. May be admitted after the prescribed period. ओके, अब ये जो है, ये आपका सेक्शन नंबर जो 3 है ना, उसका एक एक्सेप्शन फॉर्म कर रहा है. कैसे, अभी हम भी पढ़ते हैं। मे बी एडमिटेड, ये बोल रहा है एडमिट हो जाएगा, वहां बोला था डिसमिस हो जाएगा। एडमिटेड आफ्टर द प्रिस्क्राइब पीरियड इफ द एप्लीकेंट और द if the appellant or the applicant satisfied the court that he had sufficient cause for not preferring the appeal or application within such period। देखो, मैंने अभी आपसे क्वेश्चन पूछा था कि ये कौन सा ऑर्डर है, पहले तो ये बताओ। ठीक है, तो जो सेक्शन 3 था उसमें हमने 3 चीजों के बारे में बात करी थी। क्या क्या? सूट के बारे में बात करी थी, अपील के बारे में बात करी थी, और एप्लीकेशन के बारे में बात की थी। यहाँ किस किस बारे में बात हो रही है? यहाँ सिर्फ अपील की और एप्लीकेशन के बारे में बात हो रही है, करेक्ट? मतलब सूट का कॉन्डोनेशन ऑफ डिले नहीं होता। अच्छा, ये सेक्शन क्या है? ये सेक्शन किस बारे में बात करता है? सेक्शन 5 इज कॉन्डोनेशन ऑफ डिले। मतलब अगर डिले हो गई है फिर भी हम परमिट कर देंगे सूट, अपील या एप्लीकेशन को। ठीक है, तो सेक्शन जो आपका सेक्शन 3 था उसमें क्या बोला था कि सूट, अपील या एप्लीकेशन अगर लिमिटेशन पीरियड के बाद में फाइल हुआ है तो डिसमिस हो जाएगा, कोर्ट नहीं देखेगा उसको। यहाँ ये बोल रहे हैं कि अगर कोई एप्लीकेशन या फिर अपील लिमिटेशन पीरियड के बाद में फाइल हुआ है और अगर आके जो पार्टीज हैं वो आके बोल देते हैं, एडमिट कर लेते हैं कि उनके पास सफिशिएंट कॉज था समय के अंदर ना आने का, 3 साल के पहले वो क्यों नहीं आ पाए। ठीक है, दे हैड एनी सफिशिएंट कॉज ऑफ नॉट appearing before the court within the time prescribed rather than a prescribed period, if he gives such sufficient reason, then such application or appeal would be admitted। Definitely exception to section 3। पर यहाँ पे आपने एक चीज नोटिस करी, it is only applicable on applications and appeal, means there is no condonation of delay in suits। So if for for example a suit is to be instituted within 1 year and if it does not go to the court within 1 year, that suit there would be no condonation of delay for the institution of that suit। पर अगर आप if you are late in preferring any appeal or making any application, then for that purpose condonation of delay is possible। but such application or but such application, see, such application should not be under order 21। मतलब it should not be for execution। okay, so in no condonation of delay of suit can be done and no condonation of delay of order under execution can be done। ठीक है, so for the purpose of execution you have to make sure that you're giving the application for execution of a decree within the time prescribed। okay, you can't say that for example today you obtained a decree for execution, ठीक है, then आप उसको apply कर रहे हो for the execution of decree or applying to the court after say 20 years। so after 20 years you will not be able to approach to the court and ask the court to execute its decree, right? So the thing is that no condonation of delay in suit and no condonation of delay in execution orders। However, there can be condonation of delay under the appeal and application। what is the meaning of condonation of delay? Means even after the period of limitation is over, even after that such application or appeal would be admitted, but no suit would be admitted and no execution application would be admitted after the time period, but any kind of appeal or any other application can definitely be accepted। okay, now let's come to the explanation part। the fact that the appellant or the applicant was misled by the by any order, practice or judgment of the high court in ascertaining or computing the prescribed period may be a sufficient cause within the meaning of the section। it says that if due to the mistake of high court or basically if the applicant was misled, and why was he misled? Because of any practice of high court, any judgment of high court in asserting or computing such kind of period, then this is a sufficient. यहाँ पे आपने बोला ना कि अगर वो sufficient reason दे दे आके कि मैं क्यों लेट हुआ, अगर वो आके बता दे मैं क्यों लेट हुआ, मैंने क्यों नहीं विद इन द टाइम पीरियड सूट फाइल किया, सॉरी मैंने क्यों नहीं विद इन द टाइम पीरियड अपील करी, अगर वो आके सफिशिएंट रीजन दे देता है तो कोर्ट उसको एडमिट कर लेगा, वरना नहीं करेगा। और सफिशिएंट रीजन उनमें से जो भी सफिशिएंट रीजंस की लिस्ट है उसमें से एक लिस्ट ये होगी कि हाई कोर्ट के प्रैक्टिस के कारण जो एप्लीकेंट था, अपीलेंट था, वो मिसलेड हो गया पीरियड ऑफ लिमिटेशन को कंप्यूट करने में या फिर असर्टन करने में। Now legal disability, this is important, okay? लीगल डिसेबिलिटी में क्या दिया गया है? Where a person entitled to institute a suit or make an application. So there's a person who is entitled to what? To institute a suit or make an application. Just a second, guys. Yes. So, where a person entitled to institute a suit or make an application for the execution of decree is at the time from which the period prescribed is to be reckoned a minor, insane or idiot. क्या बोल रहा है ये कि where a person entitled to institute a suit or make an application, किसके लिए? डिक्री के एग्जीक्यूशन के लिए, ठीक है? बेसिकली डिक्री के एप्लीकेशन का की है, ये एप्लीकेशन फॉर एग्जीक्यूशन है या फिर कोई सूट है, दो चीजें हैं। The execution of decree is at the time from which the prescribed period is to be reckoned. Now, जिस टाइम से prescribed period start होगा तब वो क्या है? माइनर है, इंसेन है, इडियट है। He may institute a suit or make the application within the same period after the disability ceases or as would otherwise have been allowed for the allowed from the time specified therefore in the third column of the schedule. ठीक है, तो ये क्या बोल रहे हैं? सिंपल सी बात है कि जब भी सूट इंस्टीट्यूट करना है या फिर एप्लीकेशन देना है काय के लिए? एग्जीक्यूशन ऑफ डिक्री के लिए। जब से इनका प्रिस्क्राइब पीरियड स्टार्ट हो रहा है तब से जो एप्लीकेंट है वो क्या है? इंसेन है, माइनर है या फिर इडियट है। ठीक है, तो फिर अच्छा ये क्या होते हैं? ये सारे भी हमने पहले दूसरे एक्ट्स में पढ़े होंगे, आपने आईपीसी में बेसिकली इनका पढ़ा होगा डिफरेंस। within the may institute a suit or make the application within the same period of the disability ceases as would otherwise would have been allowed from time, जो कि थर्ड कॉलम में दिया गया। अच्छा, मैं आपको इसको बहुत इजी लैंग्वेज में नोट बना के बताती हूँ। टू और मोर डिसेबिलिटीज। मान लीजिए कि प्रिस्क्राइब पीरियड स्टार्ट हो रहा है 1 Jan से, ठीक है, बट जो एप्लीकेंट था वो 1 को है माइनर, ठीक है। अब वो माइनर है और प्रिस्क्राइब पीरियड तो स्टार्ट आप यहाँ से कर रहे हो, पर सेक्शन 6 का जो क्लॉज 1 है वो बोल रहा है कि आप वो प्रिस्क्राइब पीरियड कब से माना जाएगा, जिस दिन से ये मेजर होगा ना। मान लीजिए 1 ईयर का टाइम था, ठीक है, पर जिस दिन से ये कॉज ऑफ एक्शन आए हैं तब से ये माइनर था। तो ये 1 ईयर का टाइम कब से स्टार्ट होगा, इसी डेट से ही नहीं हो जाएगा, जब ये मेजर टर्न होगा ना तब से वो प्रिस्क्राइब पीरियड स्टार्ट होगा। मूविंग अहेड, where such person is at the time from which the prescribed period is to be reckoned is affected by two such disabilities, or where before his disability ceased, ठीक है। और if मान लीजिए कि when the prescribed period was starting, ठीक है, if it was starting from prescribed period from 1st of August, and at this time such person was suffering from either two disabilities, was a minor plus insane, or in the second case when his first disability ended, but when he turned major he became insane. Another disability, एक डिसेबिलिटी सीज होने के पहले ही दूसरी डिसेबिलिटी लग गई, तो वो सूट कब इंस्टीट्यूट करेगा, एप्लीकेशन कब देगा, विद इन द सेम पीरियड, वही पीरियड, मतलब 1 साल का पीरियड है तो वो 1 साल का पीरियड ही रहेगा, ये कम नहीं होगा, सेम पीरियड, बट कब, आफ्टर बोथ डिसेबिलिटीज हैव सीज्ड, जब दोनों डिसेबिलिटी उसकी सीज हो जाए तब, ठीक है। मान लीजिए एक डिसेबिलिटी तो उसकी 15 अगस्त तक हो गई, बट दूसरी अभी भी है जो चली सितंबर तक, ठीक है ना, तो उसका फिर उसका पीरियड 1 सितंबर से फिर ऐसे स्टार्ट होगा, ठीक है। ओके, अभी मैं इसको आपको फिर से बता दूंगी एक बार ना, where the disability, अभी हम फिर से डिस्कस करेंगे सेक्शन 6, डोंट वरी, वी आर जस्ट रीडिंग द प्रोविजन राइट नाउ एंड देन वी विल डिस्कस इट वंस अगेन, बिकॉज दिस इज इंपॉर्टेंट आल्सो, थोड़ा सा ट्रिकी है ना। where the disability continues up to the death of that person, his legal representative may institute the suit, legal representative, ठीक है, may institute the suit or make the application within the same period after the death as would otherwise have been allowed from time to time, so from time so specified. Means if the disability continues up to the death of that person, so uska, obviously the legal representative would be instituting the suit or making the application. So he'll get the same period, the time period which after the death as would have been allowed to him. अदरवाइज जो उसको अलाउड होता है 1 साल का 2 साल का जितना भी है, वो सेम पीरियड उसके लीगल रिप्रेजेंटेटिव को भी मिलेगा। नाउ कोर्ट, राइट, where the legal representative referred to in subsection 3, this person, ठीक है, is at the date of death of that person whom he represents affected by such disability, means the person जो कि disability में था and he dies under the disability in section 3, subsection 3, he was dying in the disability, now his legal representative is also under a disability. बेसिकली सबसेक्शन 1 और सबसेक्शन 2 भी यहाँ अप्लाई हो जाएंगे। सबसेक्शन 1 और सबसेक्शन 2, सबसेक्शन 1 क्या बोल रहा था, जब डिसेबिलिटी खत्म होगी तब से, सबसेक्शन 2 बोल रहा था 2 से 8 डिसेबिलिटी, जब दोनों डिसेबिलिटी खत्म हो जाएंगी तब से, तो सेम रूल्स लीगल रिप्रेजेंटेटिव पे भी अप्लाई होंगे। ना पर्सन जो डिसेबिलिटी में जिसकी डेथ हुई है ना, वो मर जाता है, बेसिकली डाइज आफ्टर द डिसेबिलिटी सीजन। मतलब उसकी डिसेबिलिटी थी मान लो 1 अगस्त तक, 1 अगस्त से वो उसकी डिसेबिलिटी हट गई और 5 अगस्त को उसको वो चला गया। सो बट विद इन द पीरियड अलाउड फ्रॉम एंड, बट इसका भी पीरियड अलाउड है। मान लीजिए उसका जो सूट फाइल करने का टाइम था वो 30 दिसंबर तक का था, तो उसका जो लीगल रिप्रेजेंटेटिव होगा ना, ठीक है, मान लो यहाँ, तो उसका जो लीगल रिप्रेजेंटेटिव होगा उसको उतना ही टाइम मिलेगा जितना पहले वाले पर्सन को मिलता, रियल पर्सन को मिलता अगर उसकी डेथ नहीं होती तो। ठीक है, अब मान लीजिए वो उसकी 1 अगस्त 5th को ठीक हो गया था, ठीक है, तो 5th से लेके 30 दिसंबर तक इसको जितना टाइम मिलता ना, उतना ही टाइम इसके लीगल रिप्रेजेंटेटिव को भी मिलेगा। हैड ही नॉट डाइड, अगर ये जिंदा होता, अगर उसको जितना टाइम मिलता, तो उसके बारे में बात हो रही है। एक्सप्लेनेशन क्या है? फॉर द पर्पज ऑफ द सेक्शन माइनर इंक्लूड द चाइल्ड इन द वूम। तो माइनर में कौन कौन आता है? जो चाइल्ड इन द वूम है वो भी इंक्लूडेड है इसमें। अच्छा, माइनर और चाइल्ड इन वूम अनबॉर्न पर्सन टीपीए का ही सेक्शन है, टीपीए का सेक्शन 13 एंड सेक्शन 14 परपेचुइटी। ओके, but that is not in your syllabus, so not concerned with it. ठीक है, एक बार सेक्शन 6 में फिर से बता देती हूँ इन शॉर्ट। when a person is entitled to institute a suit, या फिर एप्लीकेशन काय के लिए? एग्जीक्यूशन के लिए, एप्लीकेशन फॉर एग्जीक्यूशन ऑफ अ डिग्री एट द टाइम जब से प्रिस्क्राइब पीरियड रेकन हो रहा है तब से क्या है, वो माइनर है, इंसेन है, इडियट है, माइनर है, इंसेन है, इडियट है, तो ही में इंस्टीट्यूट द सूट और मेक द एप्लीकेशन आफ्टर द टाइम पीरियड। जब डिसेबिलिटी सीज हो जाती है उसके बाद से उसको उतना ही टाइम मिलेगा, ठीक है, जितना अगर उसको डिसेबिलिटी नहीं होती उतना मिलता तो। as would otherwise have been allowed from time to time specified therein, therefore in the third column of the schedule। For example, उसको 1 ईयर का टाइम मिला था, तो जनरली वो 1 अगस्त से लेके 23 से लेके 1 ऑफ अगस्त 24 तक करता। बट यहाँ जब वो कैसे करे, वो तो उसकी तो डिसेबिलिटी है, तो उसका क्या, ये टाइम पीरियड 1 अगस्त से स्टार्ट हो जाएगा क्या? नहीं होगा, ठीक है। तो उसका टाइम पीरियड कब, मान लीजिए उसकी डिसेबिलिटी सीज हुई 2 अक्टूबर को, ठीक है, तो अब उसको पूरा टाइम 2 अक्टूबर से लेके 2 अक्टूबर 2024 मिलेगा। ओके, 2 अक्टूबर 2023 से लेके 2 अक्टूबर 2024 तक विल गेट द टाइम, ठीक है, तो उतना ही टाइम बट आफ्टर द डिसेबिलिटी सीजेस। नाउ व्हाट इज सबसेक्शन 2 सेज? where such person is at the time from which the prescribed period is to be reckoned affected by two of such disabilities। यहाँ पे 2 disabilities हो गई हैं, और where his disability has ceased, where before his disability is ceased he is affected by another disability। मान लो उसको एक साथ ही 2 disabilities हैं, या फिर एक चीज हुई नहीं थी दूसरी हो गई, दो एक के बाद एक हो गई, 2 मिल गई उसके चक्कर में। So he is affected by another disability, he may institute the suit or make the application within that period, the same period of the both disabilities have ceased as or otherwise। तो मतलब सिंपल सी बात है, जब दोनों डिसेबिलिटी सीज हो जाएंगी ना तब। अब आप मान लीजिए इसी सेम में उसकी एक डिसेबिलिटी तो 2 अक्टूबर को ठीक हो गई, पर एक डिसेबिलिटी 2 दिसंबर को ठीक हुई, तो अब उसको जब दोनों डिसेबिलिटी सीज हो गई ना, उसको 2 दिसंबर 2023 से 2 दिसंबर 2024 तक का टाइम मिलेगा, उस डिसेबिलिटी सीज होने के बाद जो टाइम उसको मिलता, ठीक है। नाउ where the disability continues up to death of that person, उस डिसेबिलिटी में उसी पर्सन की डेथ हो जाती है, तो उसका जो लीगल रिप्रेजेंटेटिव होगा उसको उतना ही टाइम मिलेगा सूट या फिर एप्लीकेशन फाइल करने के लिए, जितना अगर वो जिंदा होता, अगर वो अलाइव होता सेम पीरियड आफ्टर डेथ एज वुड अदरवाइज हैव बीन अलाउड टू हिम। तो जितना उसको अलाउड होता उतना ही पीरियड मिलेगा, ठीक है। तो उसकी डिसेबिलिटी में डेथ हो गई, मान लीजिए उसकी डेथ हुई है, मान लीजिए 1 जनवरी, ठीक है, डिसेबिलिटी में हुई है, तो अब उसको अब यहाँ से 1 जनवरी अब जो उसको 1 जनवरी से मिलेगा, तो इस 1 जनवरी से लेके जो सेकंड जो एक साल होगा, अगर हम 1 ईयर का टाइम पीरियड लेके चले तो जो नेक्स्ट ईयर का 1 जनवरी है तब तक का इसको टाइम पीरियड मिलेगा। सबसेक्शन 4 क्या है? वेदर लीगल रिप्रेजेंटेटिव रेफर्ड टू इन सबसेक्शन 3। अच्छा, अब जो लीगल रिप्रेजेंटेटिव है इसका, ठीक है, वो भी किसी डिसेबिलिटी में है। फॉर एग्जाम्पल, अगर कोई ए पर्सन था, उसकी लीगल डिसेबिलिटी में डेथ हो गई ऑन 1 अगस्त, तो अब उसके उसका जो लीगल रिप्रेजेंटेटिव है, अब मान लो उसका बेटा माइनर है, ये भी डिसेबिलिटी में। अब इसकी जो माइनॉरिटी है ये कब खत्म होगी? मान लो वो 2 साल बाद वो मेजर होगा, तो 2 साल बाद से फिर 2 साल बाद का फिर जो 1 साल होगा इनको वो मिलेगा पीरियड ऑफ लिमिटेशन। ठीक है, तो मान लीजिए अभी 2021 चल रहा है फॉर एग्जाम्पल, ठीक है, अगर ले लेते हैं अपन, तो 2022, 2023, फिर 2023 से लेकर 2024 का टाइम रहेगा, वो उनको टाइम पीरियड मिल जाएगा। तो जब डिसेबिलिटी सीज हो जाएगी तब, ठीक है, वो मिल जाते हैं affected by such disability, the rule contained in 1 and 2, सेम 1 और 2 के जो रूल्स हैं वो अप्लाई होंगे। Now, subsection 5, where a person with a disability dies after disability ceases, but within the period allowed। ठीक है, पर टाइम पीरियड अभी उसका बचा हुआ है, मतलब उसको मान लो कि उसकी 1 अगस्त को डिसेबिलिटी सीज हो गई, जो मैंने एग्जांपल लिया था, बट 5 अगस्त को उसकी डेथ हो गई। तो अब जो उसको 5 अगस्त से लेके का टाइम बचा है ना, मान लीजिए 1 साल का था, तो अगले साल 5 अगस्त तक उसको टाइम पीरियड मिलेगा। पर ये वाला जो टाइम चला गया ना, ये रिकवर नहीं होगा। मान लो 1 अगस्त तक डिसेबल था, ठीक है, फिर मतलब था वो, एंड देन ही गॉट ओके कब, मान लो दिसंबर में, ठीक है, यहाँ पे वो 1 अगस्त को वो ठीक हो गया, फिर सितंबर अक्टूबर, पूरा अगस्त सितंबर अक्टूबर नवंबर उसने ये 4 मंथ्स यूज ही नहीं किया, ठीक है, और 1 दिसंबर को हो गई उसकी डेथ। तो अब उसके वैसे इसके 1 अगस्त को ही टाइम स्टार्ट हो गया था, तो इसका 1 अगस्त को ही अगले साल, मतलब मान लीजिए 23 चल रहा है, तो 24 में इसका टाइम पीरियड खत्म हो जाएगा। लेकिन ये 4 मंथ्स के वेस्ट हो गए, तो अब उसके सिर्फ बाकी के बचे हुए 8 मंथ बचेंगे, ठीक है, उतना टाइम मिलेगा उसके लीगल रिप्रेजेंटेटिव को मिलेगा। डेफिनेटली उसकी तो डेथ हो गई है, सेम पीरियड आफ्टर हिज डेथ जितना उसको मिलता है अगर उसकी डेथ नहीं होती तो। नाउ माइनर इंक्लूड्स दैट person or child in the womb. Okay. So I think that's all for today, and कल की क्लास में हम सेक्शन नंबर 7 से स्टार्ट करेंगे। ठीक है, थैंक यू सो मच।